This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about mutually repugnant other insurance clauses and why it's hard to escape coverage by policy wording, but for some reason insurers keep trying. Frequently, an incident occurs which may be covered by policies issued by two separate insurance companies. In such a situation, each company, through its policy, may attempt to make the other company primarily responsible for insuring the incident with its own coverage being secondarily responsible, that is, excess insurance. In this case, the issue involves interpreting the conflicting other insurance provisions between Motorist Mutual Insurance Company and First Specialty Insurance Company. In Motorist Mutual versus First Specialty, the Supreme Court of Kentucky on December 19, 2024, interpreted the application of two other insurance clauses and found them to be mutually repugnant. Although the other insurance provisions in the two policies differ, the Supreme Court concluded that they are indistinguishable in meaning and intent, something both insurers should have figured out for themselves, but they decided to litigate. If the clauses being mutually repugnant and therefore of no effect, since the provisions were mutually repugnant excess clauses. The underlying dispute between the parties arose from the tragic death of a 5-year-old child after he was struck by an all-trade employee, Tanzia, as Tanzia was driving his vehicle in an apartment complex owned by Whispering Brook Acquisitions, LLC. All Trade was party to a service agreement with Whispering Brook, and Whispering Brook retained All Trade to perform work around the apartment complex. That service agreement called for Whispering Brook to indemnify and hold harmless All Trade for all liability on account of the management of the property. All Trade was insured under a commercial general liability policy with motorists, and Whispering Brook was insured under a commercial general liability policy with First Specialty. Both insurance contracts contained other insurance provisions. Following the accident, the child's family brought a wrongful death suit against Whispering Brook and All Trade. The trial court first determined that All Trade and its employees were insured under First Specialty's policy. The court then held that Motorists and First Specialty's other insurance provisions were mutually repugnant excess clauses. The trial court granted summary judgment for Motorists, ruling that the company should share primary liability for the loss and were required to contribute in equal shares. Ultimately, the underlying case was settled with the plaintiffs, but the arguments between the insurers continued, and the Court of Appeals reversed the trial court and held that First Specialty's other insurance provision was a non-standard escape clause because the language was virtually identical to the non-standard escape clause identified in Empire Fire and Marine versus Haddix, a 1996 decision of the Kentucky Court of Appeal. The Supreme Court's analysis explained that the dispute between the parties at the trial court involved two primary issues. One, whether All Trade and its employees were covered under First Specialty's policy, and two, if so, what were the respective liabilities of the insurance companies. First Specialty's coverage for the service agreement and the liability for bodily injury were subject to the same other insurance provision at issue in this case. The Supreme Court concluded that both motorists and First Specialty's policy provided for excess coverage and therefore were mutually repugnant. The trial court, rightly, the Supreme Court noted, determined that First Specialty's policy does not include an escape clause. Accordingly, First Specialty shares equal liability to defend and indemnify all trade, Tanzia, and Key. Now, the court realized there's a difference between an excess clause and an escape clause because excess clauses and escape clauses have different purposes. An excess clause limits liability and provides that the insurer will pay for a loss, but only after any primary coverage available from another insurer has been exhausted. A standard escape clause denies liability if other valid and collectible insurance is available to the insured. A non-standard escape clause is different from an escape clause because it denies liability if other insurance is available, but also specifies that this other insurance must and may be either primary or excess. When both policies have mutually repugnant excess clauses, neither one of them will take effect, and the two insurers must share the cost to defend and indemnify their insureds. Motorists and First Specialty's other insurance provisions, the Supreme Court noted, are virtually the same. Since Motorist and First Specialty's other insurance provisions were found to be mutually repugnant excess clauses, the loss between the insurers must be apportioned and given the identical limits of liability and the co-primary coverage for both parties. The best apportionment method is for Motorists and First Specialty to contribute equal shares to defend and indemnify all trade, Tanzia, and Key. In conclusion, the Supreme Court reversed the Court of Appeals opinion holding that First Specialty's other insurance provision was a non-standard escape clause and held First Specialty and Motorists' other insurance provisions were mutually repugnant excess clauses. Motorists and First Specialty were therefore ordered to contribute equal shares to indemnify all trade, Tanzia, and Key, and the Supreme Court reversed the Court of Appeals decision in Haddix. In my opinion, this is another case proving that insurers, as professional litigators, should never litigate with other insurers, but should, by negotiation, mediation, or discussion among equals to avoid litigation, trial, appeal to the Courts of Appeal and the Supreme Court, instead of all the time, labor, expense, and argument to 3 different courts. It would have been less expensive and more in the best interest of their insureds to agree to defending those insured and resolve the plaintiff's suit for wrongful death. Only the lawyers for the insurers profited from this litigation. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 4,950 blog postings. Please tell your friends and colleagues about this blog and the videos on rumble.com and youtube.com so that they too can subscribe to the blog and or the videos. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please, for a very small fee, consider subscribing to my Substack publication. Thank you for your attention.